You will be asked if you wish to plead guilty or not guilty at the mentions court. If you face more than one charge, the prosecution may not proceed on all charges. After the proceeded with charge or charges are read, you will be informed of the punishment provided by law for the offence or offences. You will then be asked for your plea to the charges. To plead guilty is to admit to committing the offence. Here are some words you may hear when you plead guilty. Stood down charges, statement of facts, take into consideration TIC offence or offences, Newton hearing, mitigation. Stood down charges, a charge or charges to which the accused is not asked to plead, but which the prosecution may apply to take into consideration TIC for the purposes of sentence or which it may later apply to withdraw. Statement of facts. It is a written summary of facts describing how the offence was committed. Take into consideration TIC, offence or offences. Offence or offences taken into account for the purposes of determining sentence on the application of the prosecution and with the consent of the accused. A separate sentence is not passed on TIC charges, but the sentence on the charges on which the accused will be sentenced may be increased. Newton hearing. A hearing conducted by the judge to determine the facts if the accused disputes facts that will be relevant to sentence. Mitigation. To convince the judge to impose the most lenient punishment possible. After a guilty plea is made on the proceeded charges, a statement of facts will be read out aloud by the prosecutor. A statement of facts is prepared by the prosecutor to inform the judge how the offence was committed. You will then be asked if you agree with the facts. If you agree, you will be convicted of the offence. If you do not agree with the facts or part of them, but still admit committing the offence, the court may hear evidence from the prosecution and you to decide the facts. Such a hearing is called a Newton hearing. After the court has made a decision on the facts, it will convict you. If a charge or charges have been stood down, the prosecutor will at this stage apply to have it read to you in order to take it into consideration for the purposes of determining sentence if you admit to it and give your consent. The prosecution will next inform the court of your criminal record if you have one. You will be asked if it is accurate. If you do not agree, the prosecution will ask for an adjournment to prove it. The prosecution may address the court on sentence. A sentence is the punishment for the crime you have committed. If you have pleaded guilty or have been found guilty, before the court imposes any punishment, you will be given a chance to put forward a plea of mitigation. You can inform the judge about your personal and family circumstances and the circumstances which led you to commit the offence. You can tell the judge by speaking in open court or by writing a letter of mitigation. Finally, the judge will pass the sentence. In deciding the sentence, the judge will consider a number of factors. These include the nature of the offence, that is, seriousness of the offence, circumstances in which you committed the offence, example, the degree of planning, the consequences of the offence, example, the extent and nature of harm caused. If there is an increase in similar offences being committed, your criminal history, personal mitigation circumstances, example, plea of guilty, restitution, and so on.